Hello, my name is Olayinka Adeniyi. I'll be making a presentation on rethinking solutions to end child marriages in Africa, the case of SEDO, and expanding the obligation of states to holding third parties responsible in Nigeria. In this presentation, I'll be touching on some key points. I have an introduction subhead. I'll be talking about child marriage and its effects in Nigeria. I'll be talking about SEDO and obligation of states. I'll be talking about situating the responsibilities and liabilities of third-party actors within state obligations. I'll be talking about the challenges of effecting third-party liabilities through the SEDO state obligations. And I'll be giving some suggestions and recommendations, and then I will conclude. Child marriage is the union which implies the marriage that subsists between two people, one of which, usually the female in the African setting, is a child, who is not yet an adult and therefore not ripe enough for marriage or is attending inevitable consequences. The practice of child marriage from a rights perspective is an infringement of the human rights of the girl child, and it falls within prohibited harmful cultural practices within some human rights documents, both international and regional. General international documents like the Universal Declaration of Human Rights, specific international documents like the Covenant on Economic, Social and Cultural Rights, women-specific documents like the SEDO, children-specific documents like the United Nations Convention on the Rights of the Child, regional documents like the Maputo Protocol and the African Charter on the Rights and Welfare of the Child exist for the protection of the rights of citizens against practices like child marriage. These documents majorly are obligations of state to protect, respect, and defend the rights of citizens. However, it is trite that parents, families and relatives, not governments, are directly involved in contracting and engaging in child marriage practices. These people are third-party actors who should be found liable as direct practitioners of this practice, even under government or state obligations, if the practice is to be eliminated. This paper seeks to find the provision for finding these third-party actors responsible, particularly within the SEDO, and makes its recommendations and concludes. Child marriage is an ongoing practice in Nigeria. It takes many forms, as it exists also as a cultural practice in some other part of the country too, although it is slowly being eliminated, except in the northern part. It is particularly predominant in the northern part of Nigeria, where girls are often married off at low ages, even as low as the age of 9, depending on the onset of puberty. In the northern part of the country, the practice is argued as an Islamic religious adherent practice, which law should not interfere. Practitioners argue in the same line that the practice is not illegal in the country because of some inconsistencies within legal provisions. These inconsistencies appear as archaic, unclear, and provisions with lacuna in the laws of the country, including the country's constitution. The practice harms the girl child personally, physically, mentally, socially, and economically. In the long run, too, it affects the community as an impact and reflection of its effect on the individual girl child and the women's sector. It also affects the development of the society and the attainment of the SDGs in the global space. Vesico-vaginal fistula, VVF, is particularly prevalent in the northern part of Nigeria as a result of child marriage practice. There are human rights documents which provide for the rights of citizens and prohibit harmful practices. But majorly, they are about the obligations of states to protect, prevent, and defend the rights of citizens. The SEDO is one of the 9 core treaties of the human rights treaty system. It is based on 3 overarching guiding principles of prohibition of discrimination, state obligation, and substantive equality. It is also known as the Women's Convention. Its provisions include women of all ages, including girls. It contains provisions prohibiting harmful practices, but it is basically about states' obligation to protect, prevent, and defend the rights of women and girls. Article 2 of the SEDO provides that state governments are obliged to take legal steps of abolishing all existing laws, customs, and regulations that are discriminatory. In Article 3, there is a provision that government should take all physical and visible appropriate actions to ensure the advancement of women and to protect their rights on the basis of equality with men. Article 5 provides that state parties shall take all appropriate measures to modify the social and cultural patterns of conduct of men and women in order to eliminate prejudices, customary and all practices which are based on the idea of the inferiority or superiority of either of the sexes or on stereotyped roles for men and women. Article 6 provides that state parties shall take all appropriate measures, including legislation, to suppress all forms of traffic in women and exploitation of prostitution of women. Article 16 provides that state government shall take all appropriate measures to eliminate discrimination against women in all matters relating to marriage and family relations, and in particular to ensure this on a basis of equality of men and women. Article 16(2) provides that the betrothal and the marriage of a child shall have no legal effect, and that all necessary action, including legislation, shall be taken to specify a minimum age for marriage and to make the registration of marriages in an official registry compulsory. Now, we want to situate the responsibilities and obligations of third-party actors within these state obligations. It is known that individuals, parents, families, and relatives, rather than the state, are the culprits of child marriage. These individuals are referred to as private third-party actors in this issue, and it's possible to see how states, within their obligation, can find these third-party actors liable. Paragraph 42 of the General Comment provides that states have responsibilities to regulate the conduct of individuals and organizations within their provinces, particularly to ensure that the rights of citizens are not infringed. States are also obliged to engage in information campaigns to combat, for example, HIV and AIDS, harmful traditional practices, and domestic violence. This can be found in the obligation to take appropriate measures, including legislation, to modify, repeal, or abolish existing laws, regulations, customs, and practices which constitute discrimination against women, and to suppress all forms of trafficking in women and exploitation of prostitution of women and girls. And we can see that all these are symptoms or the things that we see in child marriage practice. And in taking appropriate measures, this may include legislation to criminalize, to prosecute, to find liable, and to punish these third-party actors. I want to talk about the challenges of effecting third-party liabilities through the necessary law provisions. Studies that have been analyzed reveal that the presupposition of the possibility of third parties' responsibility and liability under state's obligation within the provisions of CEDAW and as a means of eliminating child marriage has not translated into reality for this purpose. Making third parties responsible can be argued as not actually expressed within the provisions of CEDAW. When we look at the provisions of state obligations, we do not see where it is expressly provided that states can make third parties liable. For many countries, especially like Nigeria, CEDAW has not been translated into national law, whether substantively or procedurally. And what we are talking about is the fact that this CEDAW has not been domesticated, and without this, it may not be effective for the protection of its beneficiaries. And the other thing that we have to talk about as a challenge is ignorance. As at now, many people and societies are still very much in the dark about the contents or the provisions of CEDAW. Another challenge is shifting blame on religion and culture or institutions rather than individuals. Many times where child marriage is practiced, there is always the excuse that it is not an individual that is responsible, it's rather a religious or a cultural practice. And so nothing should be done or nothing can be done about it. Particularly when we talk about making these third parties liable. If they are not the ones that are responsible, then we cannot make them liable. Now, we want to talk about the ways that we can make third parties liable under SEDO. One way is to encourage the government, particularly the government of Nigeria, to ensure that SEDO is domesticated in the first part. And when SEDO is domesticated, then we'll talk about the promulgation of specific laws to criminalize this practice of child marriage. Next, we'll be able to consider the establishment of institutions and systems to enforce these provisions. And then we'll talk about engagement and or creation of opportunities for enlightenment, awareness, education on the existing laws and or on the use of child marriage practices. We'll also be talking about the support of non-governmental organizations and civil societies to be empowered to support this cause. In concluding, third-party actors can be held responsible and liable for the infringement of rights under human rights instruments. This is possible even within the provisions of SEDO. This can be engaged to help eliminate the practice of child marriage in Nigeria. This can be made possible through legislation, criminalizing the involvement or engagement in the practice, establishing monitoring of systems and institutions, providing education and enlightenment on the legislations and or the provisions of SEDO itself, or on the use of child marriage and the actual prosecution or scapegoating of perpetrators. Thank you.